You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today we are talking about Potanin versus Potanin, the recent Supreme Court case that is potentially going to have an impact on the family law community and potentially have an impact on the moniker of London being the divorce capital of the world. With me today is Richard Kershaw. Richard is a partner at Hunters Law LLP. Thank you very much indeed for
My
joining
pleasure,
the
David.
podcast,
Nice to see you
Richard.
again.
Yeah, thank you. Been on the podcast before, I know, talking about something quite different. Today it's part 3 of the Matrimonial and Family Proceedings Act 1984, and also, as I say, Potanin versus Potanin. So I thought it'd be worthwhile just initially. It's a bit of a trek through the last 10 years of litigation, but if we can give a brief outline of what this case is about in the first instance, please, Richard.
Yeah, sure. I think if you're a fan of classical Russian literature, then this story is very much along those lines. It's a long book with lots of unhappiness and a cast of many characters and lots of interwoven strands. I try and do it justice. If sort of split it down into the Russian bit first. So Russian family, married in 1983, 3 grown-up children, lived in Russia and divorced in Russia 2014. So far, so uncontroversial, modest beginnings. During the marriage, the husband amassed a fortune. Not quite sure how much that is, but it's said to be around 20 billion US. And that's a well-known story of an oligarch amassing money as one of Putin's mates who's done well out of the collapse of the old USSR and the privatisation of old state assets. No surprise to anyone who deals with cases like this in whichever jurisdiction that 20 billion's not just sitting in a bank account in one place. It's spread over many different companies and many different trusts. And that wasn't a controversial point. It wasn't as though the husband was said to be hiding any of this money. It's all sitting in structures, albeit that they're ones in which he's not the legal owner, but he's got a beneficial interest, and none of that was controversial. In the Russian proceedings, there was a dispute about when they'd separated. We often find that, and that's often to do with when the money's been amassed during the marital period. The wife said that they separated in 2013. The husband said no, it was earlier. It was 2007, probably because a lot of money was built up during that period. The wife is by no means a pauper in any of this. Okay, so in 2007, the husband had transferred to her about $71 million and then given her a further $5.1 million at the point that the marriage then broke down, 2013, 2014. There was then what's been referred to as a blizzard of litigation. Someone had calculated that there were about 43 separate hearings in Russia alone, and they'd gone up and down the court system, Supreme Court to the Constitutional Court, up and down. And at the end of that litigation, the wife was awarded about $41 million. And we say about because there's some dispute about the translation of the FX rates and the rubles to dollars and the time that was done. So there's been a bit of reflection on that in the English proceedings. But anyway, let's have in our mind that by the end of 2018, she had in excess of $100 million US. That wasn't the end of it. So we're in 2014. And about that time, she got an investor visa in London and bought a property in London later that year. She already had properties in Russia and in New York as well. So you immediately start thinking about there's a bit of clever placement of properties, bit of forum shopping going on and that sort of thing. And certainly there was some criticism of that later on. She said that London became her main home from 2017 onwards. So that's chapter 1. That's Dostoevsky, we've done 700 pages. We've got to the end of the first bit, which is not really the sort of meat of it as far as we're concerned. And then we go onto the English side of it, which started in 2017.
So if that's the start of the story, as you say, this is quite a long-winded epic almost. Let's just quickly drill into why is the Part 3 of the Matrimonial Family Proceedings Act 1984 important in all of this? What is it? What does it do?
The main matrimonial legislation in this country is the Matrimonial Causes Act 1973, and that follows Law Commission reports in the late 60s. We've still got that statute, obviously, and there's lots of talk at the moment about whether that should be overhauled or not. We're talking today about the 1984 statute, Matrimonial Family Proceedings Act, and that was brought in following consultation, Law Commission, early 80s, which identified an increasing amount of international movement of individuals. And also at the same time, the fact that many countries where there was a divorce, there was little or no provision for a wife, particularly. So it's a public policy decision emerging out of a sort of macroeconomic factors and a lack of divorce provision for wives in different jurisdictions. And so the aim of Part 3 is to alleviate adverse consequences of no adequate financial provision having been made by a foreign court where there's a substantial connection with England. So it's not just a matter of saying, I didn't do very well in Russia, Germany, or wherever, I'll go and have a bite in London. There are qualifying steps, hoops, hurdles, whatever you want to call them, that you've got to get through. You've got to establish jurisdiction. So there are jurisdictional issues about domicile, habitual residence, or the former matrimonial home being in this jurisdiction. So you've got to get over that. And then there's a further point, which is really where we start to get onto the jurisprudential meat of this case, which is the whole issue of applying for leave, permission from the court under Section 13 of the Act. So it's how best to frame it. So if you're applying for an appeal in this country, you've got to apply for permission to appeal. And then if you get permission, you can proceed with your appeal. It's not directly analogous, but it's have that as a similar sort of framework in mind. And the rules say that the application for leave has got to be made ex parte, so without notice. But the court can then direct an on notice hearing and say, I don't just want to hear from one of you, I want to hear from both of you. But typically, let's say for the past 10 years or so, and in particular since the other Supreme Court case in this area, Agbaje in 2010, the way it's run is that a client comes in, you then spend weeks or months doing the forensic work, the due diligence, getting the witness statements ready. You make the application for leave ex parte, and it's at that point that the respondent, typically the husband, finds out about it for the first time when you get leave. Of course, if you don't get leave, you just slink away into the shadows. But if you get leave, that's your aha moment, and that's when you serve it. And the court's got case management powers then to decide what it wants to do it. So we've had the Russian application, we've had the Russian divorce. That's the background to the English framework under Part 3, and that's what then happened in 2018 when she made her application for leave.
London has sometimes been accused of being a divorce tourism, which is an interesting sort of phrase. Perhaps we can use that here. This is a little tenuous. This is a lady that has had no connection to the UK prior to the divorce, but suddenly, as you say, get some properties, perhaps strategically located, well advised, and suddenly it opens up the doors to come in and putting a petition in London.
Yes, and there was some criticism in the proceedings, as we'll come on to in a minute, that she had had some legal advice 3 or 4 years earlier from a well-known firm of lawyers. We don't know what that advice was, David, because privilege hasn't been waived, obviously, but it could have been that they said, well, you need to get a proper toehold in this jurisdiction, and there are various ways in which you can go about that. But if you don't have that, then you'll never be able to make the application for leave. Some years go by, and an application for leave is then made. So, one could be quite cynical about it, or you could say, well, that was just good advice being given at the time by lawyers who knew what they were talking about.
So we move to London, and there's an application for leave from Mrs. Potanina. What happens next?
She applied for leave, and that was heard by Jonathan Cohen, very respected and very well-known family judge. He was particularly troubled by what he was being told about the Russian courts not acknowledging the concept of beneficial interests. So they divided personal assets but had ignored beneficial and trust interests. He gave her permission, he gave her leave, although he did say several times during the course of the case and the judgment that he was wondering about whether it should be an on-notice application. So at the point then the husband is then told about this for the first time, he's entitled to apply to set aside the grant of leave to his former wife. That hearing's then heard over a couple of days in 2019, and the end result was that the judge set aside the granting of the leave, and he said he'd been misled by the wife about the facts of the case, the application of Russian law, and he found there was insufficient connection with England. I think one of the silks acting for Mr. Potanin said casually, this is the fourth case she's tried to litigate, and obviously that sort of thing resonates with the judge, and that goes back to your London sort of forum shopping point. So that's the High Court. The wife then applied to the Court of Appeal, appealing Jonathan Cohen's refusal to give her leave, and the Court of Appeal then said that it's slightly balancing on the head of a pin to an extent. It said that Jonathan Cohen had been a bit too elaborate in allowing a 2-day set-aside application, but hadn't been quite elaborate enough because he hadn't heard Russian evidence or expert evidence about what a court would have done in Russia, etc., etc. So the end result of the Court of Appeal was that the wife had leave again. So the husband's application set aside was overturned. So wife emerged from that with leave again, and then we're brought up to date. We're brought up to November 2023. The husband then applied to the Supreme Court, and he applied to appeal the Court of Appeal decision. And Lord Leggatt, giving a very meticulous judgment, said two main things as a reminder of the rigorous threshold for applications for leave. It's not just a very low hurdle. And he also said that the obiter points that had come out of Agbarje about the need for a knockout blow were wrong. It doesn't need to be a knockout blow. So husband comes out of this largely successful. I say largely because two issues on the wife's appeal to the Court of Appeal weren't dealt with by the Court of Appeal, and those are going back to the Court of Appeal. So it really is sort of, you think this couple are playing Monopoly.
Saga.
Yeah, you think they're playing Monopoly, but actually it's snakes and ladders. You know, one of them wins, then they're sent right back down, and you hit a snake. But so yeah, they must be in hearing 50 plus in all of this.
We said at the outset that this has sort of been going for about 10 years. There's all sorts, as you say, 50 sort of proceedings, that kind of thing. And in fact, the judge in their judgment, and we're going to talk about that in a second, called this a rather dystopian scenario. What ultimately are we going to take away from what's been decided last week?
Well, I think as family lawyers, we've got into the habit of seeing clients who are in this position and saying, well, if the jurisdictional point is satisfied, then leave is not so difficult to obtain. And you know, that's a generalization, but that's probably the position that the profession had got to. I think it's clear from what Lord Leggatt said that is now going to be a more difficult exercise. What it probably means is that this is now much more of a front-loaded exercise. And so the applying for leave to bring these claims under Section 13 is going to be more difficult, and that the application to set aside leave where it's been granted is probably going to get a bit easier. So the knockout blow has been knocked out, if you like. That's gone. The Agbarje obiter comments about knockout blow, take those off the table. So if I'm a judge, I'm not, and I've got one of these applications before me, I'm probably going to be a bit more circumspect now about my case management decisions, about how I deal with this. I'm going to probably want to list it for a longer period of time to consider the leave application. Some of these are dealt with very, very short. You can't do justice to them, to be fair. Mm-hmm. And you know, that's a court fault, isn't it? That's a systemic fault in the courts that we've got. Or a court will say, I'm just going to list this to be heard with both of you here. And Lord Legate said it's a fundamental tenet of justice, of course, that if you're making a decision that's only based on hearing one party, that's not as good as a decision that's made where you've heard from both parties. And that's got to be right. So I think these are going to be more front end loaded. And David, we're finding that across the whole panoply of the complex financial remedy work that we do, with the thought and attention that we're putting into preparation of Forms E and directions at first appointment and should other parties be joined. So I think this is a continuation of the trend of that. That's absolutely fine. I don't think it will discourage applications like this. It might get rid of some of the more drossy ones, but typically the litigants, the clients we speak to are talking about this sort of application. There's no real concern about immediate proportionality of the costs they're about to spend and the end product, because they are ultra high net worth, they're multi-jurisdictional, and there's often a sense of injustice that drives these applications.
And you kind of touched on it there in what you've said with regard to the impact or potential impact on the wider profession, because we can sit here and talk about this case, but as you say, this is the sort of one that hits the headlines. It will have been in the Times and the Telegraph over the weekend, and it relates to a section of the population that, to be fair to many family lawyers, they simply don't deal with, and certainly don't deal with on a regular basis. But more broadly, what you're saying is that this is a continuation of a theme in terms of the level of detail that now needs to be provided in order for judges to take cases forward.
Yeah, absolutely. Obviously, in family proceedings, we don't have formal pleadings as our civil brethren do under the CPR, which are all carefully pleaded out line by line. What we have, the Form E, which is the replacement of the old affidavit of means. My view and the view of my team is that we treat the Form E very, very carefully. We treat it as though it's a pleading that's got to be gone through very carefully and very forensically. We work on the basis that whatever the ADR options are that are open to us, there's a possibility that that Form E might end up before a judge. So we've got to get it right, and we've got to do our due diligence and be very careful about it. And that's expensive, but it's the right way to go about it, in my view.
If we take a quick sideways step, we've very quickly talked about Part 3 of the Matrimonial and Family Proceedings Act and its application in this particular case, but it can be described as a controversial tool. Richard, can you just expand on that a touch? Because I think, beyond this case, it's got wider application as well.
Yeah, I think you're right. It is seen as slightly controversial. I think some of that is born out of a lack of understanding of what it entails and the qualifying factors and the need for the jurisdictional attachment and the leave stage. So I think some of it's born out of, we just see foreign litigants who've got a lot of money who are clogging up our courts, slightly pejorative spin that can sometimes be put on it. And you see that with generally, let's say the Berezovsky litigation on people trooping in and out of court. It's quite an easy target for some sections of the press to say they're soaking up lots of time. Do these cases clog up the family courts? I don't think they do, in honesty. I think the clogging up of the family courts comes below this high court level, and I think we see day in, day out real problems for our clients in children cases or in cases listing first appointments, where people are having to wait months and months and months for urgent matters to be disposed of. And it's easy or slightly lazy to elide those two and say, well, this is going on, and therefore this is causing a problem at the top of the court system, and therefore that must be the thing that's causing the problem lower down. I don't think there is actually any connection, but these cases are ripe for Daily Telegraph, Times, or what coverage. There's usually lots of money involved. They're quite exotic, and I think that's why they are seen as controversial. I think they're generative of a good narrative, as we've talked about earlier on. The sort of Dostoevsky Russian novel element to these, that is very much there.
I must admit, I find in these ultra high net worth cases, the concept of fairness gets distorted just by the sheer scale of the numbers. But this Part 3 element, and in particular in this case, it just seems so tenuous that somebody can turn up in London and try again. I didn't get my billion in Russia, so I'll try in London.
I understand that. I'll give you one. I'll give you one example. I'll change a bit of the facts. We've had clients in the past who have had a connection with another country, and if you think of European countries in particular who have automatic nuptial agreements regime in place, but they've been living in London, say, for 10 years, children at schools here, but for whatever jurisdictional reason, one of the parties, typically the husband, has been able to run a divorce in the foreign jurisdiction based on the prenuptial agreement, which is automatically binding in that foreign jurisdiction, which provides a de minimis judgment. And the wife, who may not have participated very much in those proceedings, has a foreign judgment and a foreign divorce and is living in London and is genuinely connected with London. Quite a few of the cases that we see, there is a genuine outmaneuvering by one of the parties to the manifest disadvantage of the economically weaker party. And I've got to say this, I think it is typically the tooled up, financially savvy professional husband with a network of advisors, bankers, lawyers, bring in the lawyers again, accountants, trust advisors or whatever, who've got their clever legal structure and their beneficial structures. They've got their knowledge of portability of money and jurisdictions. And we do see genuine cases of people being properly stitched up. And yes, I take the point of, well, you've got 1 million or 3 million or whatever. That's plenty. Of course it is. But the court is blind to the general objective test about whether the man on not the Clapham omnibus anymore, but whatever your up-to-date analogy is, can live off 3 million. That's not the point. The point is that a fair outcome within the context of this marriage? And the courts at all the levels of this case, and there've been many, many levels, they've all emphasised that. Jonathan Cohen, right at the start, said it's an eye-watering amount of money, paraphrasing, but this doesn't meet her needs. And you read the print again and think, how does that not meet her needs? But that's her needs in the context of this marriage. And if you think for a moment, the other side of the coin is the husband may have pocketed 19.9 billion of matrimonial money, and she's come away with 1% of that. That's where the fairness rubric comes in, and you think actually it's not about the pound, shillings, and pence. It's about the wider justice point, and that brings us back to why Part 3 came into life in the first place. It's our, if you like, our paternalistic system of having a safety net. It's not expressed as a safety net, and this is not designed to be top up. It's designed to be where there is no adequate financial provision for someone who's got a proper connection with this jurisdiction.
I think, like much of law, there are always two sides to this coin, aren't there? And this particular Part 3 element is there to protect as much as it is to be taken advantage of.
Yeah.
I think, as you say, it's quite easy at times to look at the personal situation of a case and think to yourself, well, this is ridiculous. How are they still warring over this amount of money? But it's the proportionality that you highlight that is really important in the context of the law. This particular case has been interesting. It's been really interesting to hear you go through it as well, Richard. So I really, really appreciate you taking the time to share some of your insight on it as well. So thank you.
Pleasure, David.
Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on today'sfamilylawyer.co.uk. My thanks to Richard. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.